with you, is the bottom line.
Yeah. Massive immigration fee spike, today's topic, guys. So there's a bill in Congress that we're going to go over it with you. And if this bill passes, it's going to increase fees on an incredible level, mainly focus on enforcement, but clearly has a indirect connection to legal immigration. And we're going to talk about the impact of this indirect connection. But to put things in numbers, the bill will provide $80 billion for internal immigration enforcement. $80 billion.
Huge.
And $45 billion for immigration customs enforcement, ICE. Those are the guys that run around with guns around and detain people, and so forth and so on. And then there is and how are they going to fund these numbers? By raising fees with focus on asylum and TPS, temporary protected status, folks that are here in this country, but it really has an impact on you as a legal immigrant, and we're going to be discussing it. I'm Sam Shihab with the law firm of Shihab Burke.
Brian
with me?
Burke from Shihab Burke. Said it before you even asked me.
Awesome. Brian, this is like massive numbers. This is not finalized yet, and there are things that might come into play that has even more of an impact.
Yeah, but I got to say first, we have not talked about any sort of immigration-related legislation for a long time. Why? Because it seemed like for the past several years that every now and again some congressman or senator would raise some sort of immigration bill on, say, recapture of visas, get everybody's hopes up, and it would go nowhere, and we just got sick and tired of talking those things. I think people in our audience did as well. But why is this one important? It's because it's a reconciliation bill. It has a lower threshold of passing, and they're going to need to pass a bill for budgeting. And that's what this is, essentially.
And what's that lower threshold? 50%.
50%, yeah.
50% you need, and the Republicans have the 50%.
They have the House, they have the Senate, and they have a president who will sign off on their behalf. So some bill is getting passed. The only question is if immigration components are included in it, and what are they going to be?
The filing fee for asylum is increased in thousands of dollars.
Yeah. We have a pretty good summary here. So let's see here. $1,000 fee for asylum applications, which previously never had an application. Let's see here. $550 every 6 months for a work permit for which is huge.
For asylees and for TPS, temporary protected status.
Yeah.
And $100 for every year the case remains pending.
Yeah. $1,000 for parolees. Let's see, a $250 visa integrity fee to be paid for any visa issued abroad. Well, that's something that will hit people in our general lawful immigration audience.
Yes.
And a fun one, a $24 minimum I-94 fee to be collected at any time individual requests an extension or change of status, which does add up. I mean, think of, it becomes significant money when you say, I don't know, process 85,000 new H-1Bs each year, with most of them being changes of status, for example.
And they're hiring thousands of additional ICE officers, many hundreds of additional border officers.
Yeah, I've heard 10,000 ICE officers.
10,000 new ICE officers.
Yeah.
Now, when those guys cannot find illegals, where do they go and go after who? And we've seen that already.
Anybody who fits the bill, or any people who are lawful and they can go after. I mean, you're
on a questionable situation or in a transitional period or any of those things.
Yeah, I mean, you're thinking about those students for example.
They've had so much pressure to meet a quota to deport people.
Yeah, so they can have the biggest numbers ever. Yeah.
Yeah, they want to deport 1 million person per year.
Yep.
1 million person per year. That's the goal. And when they don't find illegal individuals to deport, who do they go after to meet the 1 million on the last day of the month?
I want to hear your answer to this question.
Anybody.
Well, yeah, I mean, the story, I mean, obviously deportations have been a big news story, and what they've been going after right now is, I guess, what we would call, for lack of a better word, low-hanging fruit. People with deportation orders ready that they can find, pick up, and remove. Where the controversies have been and are going to, it's basically about offering process offering process for these people, due process for the people they're trying to remove from the United States. And one thing that really isn't on this list as a significant upgrade, this is not in our notes here, Sam, but it was one of the articles I was reading. There's a big, border security, border patrol, detention. These are things that are all big on their menu, but a whole lot less of an increase for immigration courts, which, the people who basically judge the legality of the government's plea to deport you from the country, which is kind of problematic in my mind, because that's the big controversy right now. They've been talking about suspending habeas corpus, so they can just do whatever they want with removal, for example. So
the work permit for parolees is going to go up to $550.
Yeah.
Right now, I think they're saying $520 for paper or $470 for online.
So yeah,
plus $30 a biometric, $550.
Yeah, the standard fee is right now for a EAD is $520. It's a matter of who they're charging. They're charging more people for it now. Yeah.
Yeah. TPS $500 for work permit.
Yeah.
We talked about that.
Yeah. All categories previously not subject to fees for a lot of the.
And you said the non-immigrant integrity visa is $250.
Yeah.
The diversity visa, which is you don't have to worry about that for legal, but the diversity visa increased. And adjustment of status, they're tacking $1,500 on that, Brian. But it appears to me that the adjustment of status fee is only if you are before the court, but it's not clear. So we don't know.
Yeah.
We don't know. But I don't think that's going to affect.
Well, let's take a pause for those who have maybe tuned in a little bit late. We're talking about a reconciliation bill there's some form of it's going to be passed. There's talk about adding lots of immigration fees. Nothing is set in stone yet. We don't have a final version yet, but it's an interesting topic anyway.
One of the things that people are worried about is that this bill, at the very last minute, they are going to include the public charge rule that was 2019 passed by. Proposed by Trump and implemented by Trump 1.0, and that bill, the word on the street is 50% of U.S. citizens would not pass that.
Yeah, let's talk a little about public charge. So if you're immigrating to the United States, you can't be a public charge, somebody who's likely to be on public benefits in the United States. And generally speaking, a lot of people in our audience are employment-based immigrants, and they generally never had to think about it that much. Basically, if you have a bona fide offer of employment pursuant to your I-140, they would never really ask you anything about public charge in your green card application. But travel back in time to October 2020 when Donald Trump was president and we were filing tons and tons of green cards. You, me, and everybody else in our office, Sam, were printing off tons and tons of documents. I think it was for a form called I-912, maybe? It was the public charge form, an additional form that basically they sort of gave you your entire financial history, a medical exam, to asking you for tons and tons of personal information about your credit, about your education, so they could evaluate whether you are public charge. And a court overturned those rules, as I recall, before they even really judge any cases on them. But the bottom line, I guess, is that what they did last time is they created a massive additional burden in filing adjustment status in terms of the documents you had to give, a massive amount of additional work. I mean, literally, we probably burnt not 500, not a full ream. What is it? About 500 pages in a ream, but about half a ream per case in terms of just public charge documentation. Miserable stuff, and they'll reject your case if you don't include it, and that's that. Yeah.
Do you think that we're gonna get that again this time? Because that would be a serious problem in terms. I mean, it was miserable.
Yeah. Well, I don't. If I'm thinking about the mindset of the current administration right now, I don't really think public charge and green card applications for people who have already gotten here is their big concern. I mean, I think if that's the big wall we're setting up, that's too late. I mean, these people are border focused. It's I'm going to stop you from coming to the United States in the first place. So, I mean, I read the same sort of news articles you've had. There's talk about adding a public charge back in as it was in 2019 to 2020. It wouldn't surprise me if it came back, but again, I'm going to get into their head and say that creates more work for the Immigration Service that I don't think achieves their goals. I think what achieves their goals is exactly what they're going for here: sucking money out of people and making asylum expensive. Yeah.
It is the single biggest increase in funding enforcement history in this country.
Yeah, huge.
Let's switch gears and take questions, Brian, and then we want to go into immigrationquestions.us.
Oh, yes.
This is a website that we own where you drop questions during the week, and we get to answer it for you. And taking the first one of them here, one of the people were asking, how does my prior dismissed criminal case affect my naturalization application? Which is an excellent question. How does my prior dismissed criminal case affect my naturalization application? So number one, to be able to naturalize, to become a U.S. citizen, you have to be a person of good moral character.
Yes, for this.
For a period of 5 years. So
3 years if you're married to a U.S. citizen, but for employment-based person, 5 years, yeah.
Thank you. Now, here's one thing you should know. If the criminal offense occurred outside the 5 years, but if the probationary period or the penalty imposed goes into the 5 years, it's fair game to drag it in and evaluate it.
Were you listening on the door at my consultation this morning? I was talking to a guy this morning about this very...
I listen to the door to your consultation every day, Brian.
That's the kind of time you have on your hands. I was doing a consultation in this very room. Somebody was sitting right there, and he was thinking, okay, so I had this criminal thing. I just have to wait 3 years. I said, no, you have to wait 3 years from when the punishment is
has
over.
ended. So if you got like a 2-year probation, for example, for a DUI or something, you have to finish the 2-year probation and then 5 years for it not to count.
Yeah.
So that's number one. Number two, the nature of the crime is very critical, because according to the new Trump 2.0 policy that passed last month, Brian, if the person had committed a deportable crime, offense, 25 years ago,
if you're still subject to deportation.
Therefore, make you subject to deportation, although you have maintained fantastic, good moral character for the prior 5 years. The policy says deport that guy, don't give him citizenship. That's a major change in the policy, because that never happened before. Because if the person was deportable and the offense was so old, it's insignificant. Hey, when I was 19 years old, this happened. Now I'm 55 years old, and I have been an amazing father, an amazing human being for 20 years.
Yeah, I was worried.
Deport this guy according to the current policy.
I was worried about this, as soon as the election happened. I had a case with somebody with domestic violence charge in the past. I was in the Columbus field office, and right after the election, and we knew who the president was going to be. And I said to the officer, can you be fast about this? And she's like, don't worry about it. It's a long time ago. It doesn't affect you at all. It can.
It does now.
Yeah, exactly.
Because that person did not read that policy. It wasn't out at the time. Give me one, Brian.
Yes. So from Elithi, immigrationquestions.us. My 2 boys got the U.S. passport when their mother got her citizenship and passport. They were younger than 8 years old. My question is, are they supposed to be naturalized? If yes, what is the process? So the short answer to this question is no, because you've already told me the answer. If your children have U.S. passports, they are U.S. citizens. That's sort of it. What they might consider getting.
And how did they become U.S. citizens?
Speculating. I always quote the wrong law. I believe it's the Child Citizenship Act. That's the one in your mind. It's a law that says if there's a child permanent resident living in the physical and legal custody of their U.S. citizen parent, they become a citizen. Bam. Okay. And it sounds like this person will definitely qualified. And the one thing they skipped, which is optional, is that they not apply
for a certificate
of citizenship for the kids.
Of citizenship.
Yeah, so those children are U.S. citizens, per what this person has told us. They don't have to naturalize because they already are citizens.
Would you recommend they file for certificate of citizenship?
Yes. Because all it takes is for those passports to, I don't know, get lost or stolen, and then suddenly that child has no evidence that they are a U.S. citizen. Rough. It doesn't hurt.
Why would you revisit the custody and all these elements of the law? I would not recommend that you file this. Now that's why, and that's why
I'm gonna fight with you. Don't worry, Sam. I'll fight with you.
And that's why you need a second consultation.
Yeah.
That's why you need a second consultation. I would not recommend it without consulting with an attorney.
Oh, sure.
Because, Brian, this type of filing can trigger hell if there is technical issues that wasn't discovered before,
Well,
and the passport was handed during an era of forgiveness and happiness and love, and now we are in an era of
what's the opposite of love?
Picking on everything.
Yeah.
So I would want a good, experienced lawyer to walk you into, let's go through this process, what happened when they were young, and if it all looks good, you file it.
So you're
if it
thinking of a
doesn't look
scenario.
good, don't file
Well,
it.
yeah, you're thinking of a scenario where that child, under the people who are in power now, they might not consider that child to be a U.S. citizen at this point. Even though they have a passport.
There are gray interpretations.
Yeah, and we've encountered those in this
You could
office,
be
yeah.
in an area of law that was interpreted one way back then. It could be interpreted differently now. I'm not saying that's the case here. I don't know anything about these people. All what I know is that don't file this on your own.
Yeah. Raise your hand if you've seen a case where the Department of State has given somebody multiple passports in the past and then has come back later and said, our mistake, you're not a U.S. citizen.
20 years later.
Yeah, yeah.
20 years later.
Oof. Yeah.
20 years later, yeah.
Yeah. So I guess that's something to be clear. You know, people think, you know, one of the topics we had a couple weeks ago, Sam, it was, you know, can they take away your U.S. citizenship? And our answer to that was yes, but it depends upon your circumstances. One thing they can do is say, no, you were never a U.S. citizen in the first place. And that's one of those fun, great nuances of U.S. immigration law you just can't help but love. There's no res judicata on your U.S. citizenships. It's oops, and we're not giving you a new passport. You know?
I have a good friend of mine who every time he talks to me about immigration, and he happened to be he's a U.S. citizen but came from a different country, as I did. And I would say, no, you're wrong. And he goes, no. You, because you're a lawyer, you see things, so many bad things, you're colored with you don't have a problem until you have a problem. And don't assume, because that's the first mistake you can make. So definitely talk to an attorney. Let's go to the next question here. And we definitely want to take questions from people listening to us.
We got some live ones, yeah. Let's hit one of the live ones right quick. Sure. So from Sunny here. My child would be going to a pre-kindergarten/Head Start program in Maryland. Will it cause problem? Oh yes, that function. Will it cause problem in my green card change of status application, adjustment of status application? Will it be considered public benefit? My child is a U.S. citizen by birth. Now, as a lawyer, Sam, I love it when there's enough facts to make me not have to think that hard. And when I see that child is a U.S. citizen by birth, that's kind of the end of it for me. That child's allowed to take whatever public benefits that child wants, is the bottom line, until they rearrange the public benefit. The public, it doesn't seem really likely though. Yeah.
Okay.
Yeah. I mean, you have an alternative take?
I don't have an alternative take, but I haven't thought about it enough to give that very solid answer.
Yeah. Well,
in my opinion.
Well, if you hear me go ahead. Yeah.
Here's why I haven't thought about it enough. Because he's a child.
Yep.
So the public benefit need that the child has, could it be imputed on the parent? I'm just asking. I'm not saying.
Well, if you heard me trailing off at the end of me saying that, I was like, well, under as the way I understand it, the answer is no. But welcome to the crazy, wacky world we're living in. We're talking about a massive revision in the public charge rules. But I mean, let's think about this thing. I mean, let's say if you wanted to evaluate that benefit, it usually has to be a cash supplement, a means tested benefit, right?
Yeah, if it is, either that or it's dependent on the father's income. For lower income family, is available.
Yeah, I mean,
I would say it looks positive, but you really need to look closer at it. I wouldn't say 100%, Brian, even though the child is born in the U.S. It's just because I haven't read the law in that area enough or recently. to, I don't have an encyclopedia in my head.
Well, that's always a healthy thing to think. Number one thing I like to say during consultation is part of me being good at my job is knowing what I don't know off the top of my head, what I need to look into. I mean, I agree with you that.
You know the beauty about our office and many other offices that way. We're not advocating our office. I mean, there are different types of practices, immigration practices. We're 6 attorneys in this office, but every case is for everybody to work together on. It's not like my case, your case. We work together and we talk, we meet, and we review cases together, and that's how we keep consistent work product. That's an excellent one. So I got another one here. Somebody was. Okay, so explain how TUB works if the priority date is not current.
Okay, Sam, I'm going to give a very concise answer here, and I think I'm going to force you to agree with me. It doesn't work. It's broken. That's impossible. Well,
it doesn't work.
Well, so
why?
Because if you read the USCIS policy on transfer for underlying basis, they make it clear that there must be a visa available for you to.
As a prerequisite to transfer the priority you're transferring to, not from, to, must be current under final action date or filing date.
Final action date, because I'm literally pulling up the website right here. Let me see. Visa immediately available. When an applicant requests to transfer a transfer of the adjustment application from one basis to another, the priority date must be current for the category the applicant wishes to use. There you go. And that's that. Now, people, just to be clear, when you send in a TUB, man, I don't think they really look at them very hard, at least not very quickly. And I have no doubt that there are people out there who have sent in TUB requests that are untimely and not gotten them sent back because they don't really analyze them that hard. They just don't consider them, in my estimation.
All right, sounds good. That's a good question. So is that a question here?
Let's find out.
Or LCA date? What's that question here? We can.
Well, I think it's part of a question. And it sounds like Senthil Kumar's employer is going through, I don't know, some sort of
company address change. Yeah. Can you give us the complete question? This is missing. Is incomplete.
Yeah. If any questions that were asked before we got started, we're not going to get them in full.
Or
here.
you can drop them on immigrationquestions.us. During the week, and we can definitely get you answers. So here's another one that we got, Brian. How do I know if my PERM case is EB2 or EB3? That's a great question.
Me being me, I can't help your PERM. Whether your PERM is EB2 or EB3, your PERM really isn't EB2 or EB3.
It's nothing.
It's a job offer.
Yeah, there is no box.
I'm surprised you're going to accept this answer from me.
Well, no, I'm continuing.
All right.
It's an interesting question because a lot of people ask that question. There's no box on the PERM
that says EB2 or EB3.
Is this case EB? Okay, I'm going to check it EB2. I'm going to check it EB3. The way the PERM work, it organically creates the opportunity for future filing under EB2 or EB3 when you do go to the I-140 petition. But when you're drafting the PERM, the considerations are not.
Yeah, one of the things maybe people don't understand is PERM, it is, but it's not an immigration, capital I, process. It's not a USCIS process. It's a Department of Labor process. If you talk to the Department of Labor about immigration, their eyes cross. I once had a Department of Labor. We did an appeal once for somebody where a PERM was denied, where they were fighting about whether somebody's a U.S. citizen or not, and the Department of Labor got their butt served on a platter because they had no clue what they were talking about on immigration.
Back to the question, Brian. You've digressed a little bit.
Well, here's the short answer.
How do I know if my PERM case is EB2 or EB3? You don't.
You don't. Yeah.
Okay. However, you would know if your case has the opportunity to be filed in EB2 or EB3, potentially.
Yeah.
And the opportunity is presented when the job degree requirement is either a master's degree, used equivalent to a master's degree, or a
bachelor's degree of 5 years of post-graduation progressively responsible experience, and those get you in the EB2 category. But
and 5 years of experience, and a bachelor's degree with progressive experience. if the job is not the experience you have, is the job.
Yeah, that's the word people, they say, Brian, I have 5 years, I have 20 years of experience. Aren't I eligible for EB2? Not unless your employer is offering a job that meets where the experience requirements for the job meet yes, you greatly exceed them, but their stated requirements, their stated minimum requirements for the PERM process are below, and that's that.
Okay, sounds
so
good.
I'm gonna hit one of these questions here, Stan, that we have live going.
Sure.
This is one that I've heard as well, and it sort of baffles me. Heard the government cutting back staff in USCIS. What happens to time-sensitive proceedings? So initially,
so the cutting staff.
Yeah.
Where is that coming from? Because these are not tax-based jobs.
Yeah, well, I heard there's part of the reduction of force offers they're making to everybody else. They eventually got, one of those, hey, if you'd like to retire,
Okay, so that could be a rotation. They're trying to get older people who are more expensive and hire younger people who are less expensive.
Yeah.
Legally.
Yeah.
The legal way. You're working for USCIS for 20, 25 years. You're making $80,000 a year because of all these promotions. They'd like to retire you. Give you an open retirement. So open a slot to bring a younger guy.
Sure.
Who?
Well, I don't think they're planning on. Well, in USCIS, they might actually replace those people. I have a friend who works in government in DC for an agency that has, I think, like less than 1,000 employees, and he told me the number of people at his agency that allegedly accepted, that sort of thing. It was measured in the hundreds.
A lot.
Yeah. Great.
I worked 40 years ago for the government. For the state government, for 2 or 3 years. You know what the number one question when you work for the state government?
When do you retire?
How many years you got to retire? Those guys, which was shocking for me because I was very young and I was anxious to do good, And the next question is, I got another 2.5 years. I got 4 years. That's what they talk about. Yeah. They love to retire. So go ahead.
Well, so what happens to time-sensitive proceedings?
We have no information. We don't want to spread fear here. We have no information that there's any slowing.
Yeah.
We haven't noticed it.
Yeah, I will tell you the processing time that I think about the most, that I look up the most, because people ask me about it the most. It's how fast does a green card, family-based green card, take to process here in Columbus, Ohio? And it has been pretty much solid, about 13, 14 months, actually faster than that in practice. For as long as I can remember.
You haven't had this administration long enough to draw a conclusion, right?
Well, sure. I was expecting it just to go up in general over time, but I don't think it's a this administration problem, because I don't really remember.
As a matter of fact, there has been some acceleration.
Yes.
There has been some acceleration based on the F factor, the fear factor. I think people, we've seen.
I have seen some cases come to interview.
How about Labor Department moving a little bit faster? Did they not move a little bit faster?
Prevailing wage requests are down to in the 5 months, but labor certifications are still at a 1.25 years, to the best of my recollection. I haven't looked in the last maybe week or so. I haven't been paying attention to the time. Just happy that they're coming in at all.
Yeah.
Yeah.
All right. So. Do we have anybody here from the Talk to
San? Yes, a frequent viewer, because I remember names and handles like this.
If filed I-45 through my previous employer in 2022 as my I-140 was not approved at that time with the current employer, I got an EAD in October 2022. I filed. Now that my I-140 approved with the current employer and EB2 prior date India is current, what to do next?
Oh, well, that, you mentioned TUB. But
sounds like transfer underlying basis is option number one. If you are working for an employer who would sign off on a supplement J and for a same or similar job classification.
It doesn't have to be it. It doesn't have to be that. It's not the same. It's if this, as I'm understanding it, is there's a prior I-140 with a company A, right? And then now they're with company B, and company B now has an approved I-140.
Yeah.
So I'm going to go back to it. I-45 from a previous employer in 2022. So he's with his current employer now. His previous employer, he filed the I-45 through them because he didn't have the I-140 approved with his current employer, right? Now he has an I-140 approved with his current employer with a current priority date. And that, I think it sounds like a Tubb scenario.
So either that, sounds like a transfer underlying
Yeah,
basis.
it's the same form, same supplement J. You just
Supplement J.
There's just no same or similar occupation analysis. It can be
Dr. San, you need to hire a good lawyer to help you with the transfer underlying basis and keep things moving.
Yeah, I love doing a transfer underlying basis because it answers the question of Brian, how can I get USCIS to pay attention to my case? Well, send them something that you look at, like a transfer underlying basis.
Yeah.
Because even if you didn't need to move categories, I'd say your priority date's current. You want to try to get them to move. You send a letter to them, basically saying, "Hey, case current. You have an excuse to send a letter. Transfer underlying basis."
Now, Brian, when are we coming back next time?
We will be coming back on Wednesday at 6 p.m. as we tend to do.
And do 30 more minutes.
Yeah.
So give us feedback, guys, whether you like the 30-minute option. And drop your question at immigrationquestions.us because we're running out of time.